Good afternoon. This was scheduled to be a pre-hearing conference in Public Service Board docket 8784, an investigation pursuant to 30 VSA's section 30 and 209 and Public Service Board Bill 5.110D into the application of Benson GLC Solar for a certificate of public good for a 499 kilowatt interconnected group net metered photovoltaic generation facility in Benson, Vermont. The board opened this investigation in response to a complaint filed by Mr. Reginald Benjamin. And the goal of the investigation is to determine whether Benson GLC Solar's construction and operation of its project are consistent with the terms of its CPG, and if not, whether it is appropriate to order any remedial action, impose a penalty, revoke or amend Benson Solar's CPG, or take any other steps authorized by law. My name is John Cotter. I'm the staff attorney at the Public Service Board, and I have been appointed to serve as the hearing officer for this proceeding. We can start out with appearances with the department, please.
Jeannie Elias with the Department of Public Service, substituting today for Stephanie Hoffman, our attorney assigned to the matter, who could not make it.
Jen Mojo with the Agency of Natural Resources.
David Carpenter from the firm of Basie Goss and McPhee representing Reentry Capital and Benson GLC Solar.
Okay. Well, we are here. It turned out to be a rather snowy day. We were scheduled to start at 3, but Mr. Benjamin, the gentleman who filed the complaint that initiated the investigation, is not here. The clerk's office did not receive any communications from Mr. Benjamin indicating that he would not be able to make it today. I should note that he earlier was offered an opportunity, not earlier today, but when we were scheduling this pre-hearing conference, he was offered an opportunity to appear by telephone, given that he lives a fair distance away, but he declined that opportunity. So I don't think there's a whole lot that we can do today, given Mr. Benjamin's absence, since he did file the complaint that initiated this investigation. So do the parties have any suggestions?
Well, I thought I recalled from some of the department's interactions with Mr. Benjamin via Cappy that Mr. Benjamin may be elderly, and that Mr. Benjamin may also not be very high tech. So it could be just possible that he started out and did not have the means to make a telephone call en route. So I would like to ensure that the weather and other factors didn't prevent his attendance today before we take any permanent action.
Okay. A&R?
I'm currently here to monitor the case. If any of A&R's interests are raised, I'll have an attorney sign the case, but at this point, I'll just monitor it.
Okay. Mr. Carpenter?
Sure. There's a couple of issues. First off, Mr. Benjamin has also filed a private nuisance action in Rutland County Superior Court against the same defendants, which is currently pending. That was filed in July, shortly after he filed this. He filed an affidavit as well with his complaint to the Public Service Board, which was filed at the end of June. Attached a number of different photos to it that allege showing glare at his property. We have some concerns about the complaint. The first off is that he did not participate in the proceedings below. He's a direct abutter to the property. He was properly notified. He received the 45-day notice, and he also received the notice of the application as well. Chose not to participate, filed this about a year after the CPG was granted, and after construction was completed. There's an exhaustion of remedies question. These are all aesthetics issues that should have been raised. Basically what he's trying to do is get a technical hearing a year and a half after the application was filed on aesthetics issues. The department didn't raise any of these issues. The A&R didn't raise any of the issues. The town didn't raise any of the issues. The Planning Commission didn't raise any of the issues either relating to any of his discussions about impacts to public resources such as the roadways and so on and so forth. Basically what Mr. Benjamin is doing is he's trying to litigate his private nuisance action in two forums. And all of the complaints that he makes in his complaint to the Public Service Board relate to impacts to his particular property. There is no allegation in his complaint that this facility was constructed in a non-compliant fashion with the CPG, which is what the order opening the investigation suggests. It's basically our argument that it should be dismissed, or if nothing else, stayed and pending the conclusion of his private nuisance action.
Okay, I should just point out to you that, the board doesn't view an investigation like this typically as a private claim on behalf of, private interest of an individual relates to the board exercising its general supervisory authority over holders of certificates of public good to ensure that the certificate of public good is actually being complied with. That said, if you would like to file something with the board, pick a date for a deadline and go ahead and do that. But I think in the interim, I will probably, it sounds like Ms. Elias, the department, will be trying to get in touch with Mr. Benjamin. I'll probably have the clerk's office also try to get in touch with him to see what happened, and then take it from there. And when their motion comes in, the board will take it under advisement.
The only other question I would have, Your Honor, is with regard to whether or not he's going to be required to file a motion to intervene at this point, which is generally the way the board has handled these issues in the past for exactly the same reason you stated, is that if the board doesn't look at it as a private cause of action, it's a public cause of action, he has to intervene as well. So
Yes, that's correct. He would have to ask to become a party. I don't know what level of formality the board would require from him, given the circumstances. My understanding also is that he is a fairly elderly gentleman and maybe isn't so versed in the ways of using computers and so forth. So, what level of formality the board might require isn't clear to me as I sit here today. But yes, he would not automatically be a party to this proceeding.
well, and for the record, he is represented by Peter Langrock.
He is not represented by Peter Langrock in this proceeding.
Correct, Your Honor. I didn't mean to suggest that he was, but in the private nuisance action, he is represented.
Yes, we're aware of that. In fact, we weren't sure if Mr. Langrock was going to be representing Mr. Benjamin here or not, but we did receive a letter from Attorney Langrock a little while back acknowledging that he was representing Mr. Benjamin in the suit, it's in Rutland County, I believe. Correct. But that he would not be representing him before the Public Service Board.
Okay. Is there a way that we can get copy on these things? We didn't, and maybe it's just a board process function. We didn't get a copy of the initial complaint when it was filed. We got a copy, maybe, I don't know, probably the same time you guys did.
Yeah, generally the board doesn't affect service on people, but in this case, probably it came in from Mr. Benjamin. He probably didn't realize that he needed to.
I'm sure he did.
People. So, at this point, you have received all the complaint materials. It sounds like you have.
As far as I know, if we have a complaint that was stamped June 27th.
Okay, let me just get caught up with you here.
Mm-hmm.
Yes. What was it titled? Complaint about blinding glare from solar array.
That's the one, yep. And it appears that there was also an affidavit filed, wherever that is. Bear with me for a second. I thought I saw it. There it is. This is what happens when you don't send your copies. Affidavit of Reginald Benjamin, July 14, 2016, stamped 2016, July 22.
Yes.
Okay.
Yep, and that's the affidavit that had some pictures appended to it.
And yep, that's pictures attached to it. And is that, and then apparently there was a letter from Peter Langrock?
Yes.
Okay.
Did you get a copy of that?
We did not get a copy of that. Those are the only two documents we have. So anything else, I'd appreciate if I could get a copy before we leave today.
Could you dash over your copier to me?
I can.
And actually doesn't look like the department received a copy of this, so if you want to make one for
We
yourself.
did not. So I will do that, but I wanted to, before we left the issue of the potential motion from Attorney Carpenter, again, I inherited the duty to attend today just a short while ago, so I'm not as well versed about this matter as I might have been where I hope to have been originally assigned to it. But I do note that the matter is pending, and that when the motion to dismiss comes, the department is going to examine its obligations on behalf of the public to determine whether this case should proceed, even though initiated by a complaint from Mr. Benjamin. The board has previously included conditions in certificates of public good with respect to glare and potential safety issues in docket 7594, the Ferrisburg Addison Solar Project. And so we are aware that the board has, under certain circumstances, looked into glare issues before, and to the extent that there is some allegation here that there's a health and safety issue as well as an aesthetic issue, the department would think it important to at least examine that at some level. And so our answer to the motion to dismiss might not be, oh, well, Mr. Benjamin didn't come, and that's the end of that. So I just wanted to make that clear. We haven't made any determinations on that, but that is something that I think within our obligation to do, and we will do it upon the filing of the motion.
Fair enough.
Okay.
So do we want to pick a deadline for your motion, or
That would probably be the appropriate thing to do at this stage, wouldn't it?
why don't you shoot one at me?
I would like for it to be in the first part of the new year, given the chaos that ensues between now and the end of the year.
Mm-hmm.
So maybe somewhere the week of the 15th.
Sure, you want to pick a day?
Why don't we say that, Friday?
So would that be the 20th?
Yes, ma'am.
Yeah.
And may the department have 2 weeks to respond?
Sure, so you want to respond on
February
3rd?
That could be enough time.
I'm not positive because I don't know Ms. Hoffman's schedule. So I just thought I would take a shot at it, and I will get back to the board and parties if Ms. Hoffman has other commitments or doesn't think she can turn around a response.
I don't have any problem with
Okay.
extension if we just want to put that date down and
Okay, we'll put that down as.
we can move it.
Okay, and then, yeah, if you need an extension, because I'll probably get out a pre-hearing conference memorandum in the next couple of days, but if it turns out that Ms. Hoffman needs an extension, just, it sounds like counsel for developer is amenable to that. so.
Okay, I've made some notes to that effect, and I'll have Ms., if possible, I'll have Ms. Hoffman quickly get back to the board and parties so that if that date works, then we can be in the pre-hearing conference memo and no extensions need to be applied for, or if converse, then maybe we can agree on a new date and shoot it to you before you develop the memo.
Okay, fair enough.
And then in terms of service yard, you guys are gonna want one, are you gonna want a service cooker? So, I don't think that procedurally changed in terms of number of copies within the rules. Procedural stuff didn't change, did it? Like 3 copies to the.
The net metering rule? or-
Yeah, there were no
No.
procedural changes into Rule 2.
No, it's, at this time, especially because it's a hearing officer, not the full board,
Oh, yeah, fair
sitting on the case, it would be an original 3 copies.
Yes, all right.
That's what I thought. And then if we ever got into any written discovery or anything like that,
You
you
get one copy.
just send the 1 copy and,
Yeah.
you know, you didn't look at that.
And then if EPSB happens, then it happens with net metering, and you elect to go forward with electronic, then you can, right?
Well, it would depend. This would be considered what's called a legacy case, because it's a case that was open before we actually implement the electronic filing, so it would have to be something that the board decided to move over into the world of electronic filing in its entirety, and assuming that's what the parties wanted to do.
I'd have no objection.
Yeah.
To be perfectly frank.
But the board would have to be okay with it too.
You want me to throw that in my motion too?
Yeah, it's not clear to me that, that net metering cases will be immediately available for processing when we go to electronic filing. Looks like there may be a delay of a few weeks anyway, but we do hope to get them there, that's for sure. So, well, then why don't we just go off the record really quickly, Jeannie, if I could ask you to get some copies, and we'll just memorialize for the record that you did that.
Will do.
Thank you. Going off the road, and
Yeah.
showing up with any order.
He was off. I didn't make one for you.
No, I don't either. Thank you. Yeah, it's kind of funny to watch.
Okay, let's go back on the record really quickly. I'd just like the record to reflect that Ms. Elias was just kind enough to make photocopies of a November 11th, 2016 letter from Attorney Peter F. Langrock to Holly Anderson, the Deputy Clerk of the Board, indicating that he would not be representing Mr. Benjamin in this matter before the board. And apparently Attorney Langrock did not provide copies to Mr. Carpenter or Ms. Elias. So Ms. Elias was nice enough to just make copies, and we got everybody copies who needed to get them. Other than that, is there anything else we need to discuss before we adjourn for the day? Okay, hearing that we're done, we are adjourned. Thanks for coming. Sorry folks had to drive in the snow to get here.
Thank you.